Buongiorno, buongiorno a tutti. Bene, benvenuti a questo ultimo incontro di Creativity 2020, questa nostra 15ª edizione. Oggi parleremo di un tema molto particolare, quello del diritto d'autore, in particolare il diritto d'autore in quelli che sono gli ambiti, diciamo, della creatività. Abbiamo con noi Olga Venetska, una esperta del settore. Olga è una consulente nell'ambito dell'IP, quindi della proprietà intellettuale. Lavora moltissimi anni nel settore, in particolare per il settore televisivo e in particolare per il settore web. Questo è l'ultimo appuntamento appunto dei workshop di workout del Creativity, e quindi andiamo ancora un minuto e andiamo a presentare Olga Venetska e il suo intervento. Ok, Olga ovviamente parla inglese, si trova in questo momento a Kiev, che è la capitale dell'Ucraina. Hello, Olga. How are you?
Hello, I'm fine. Yeah, how are you? Are you ready for that?
Yes, we are ready. Thank you for coming. Thank you for joining us. And I suggest you to talk slowly because our guys are all basically coming from the high school and from the university, the first years of the university. So they talk in English, but it's better to, especially in technical things, to go slow. And we are very happy to have you here. And I give you the stage. So if you have to share if you want to share your screen, you can go ahead. And in case of questions and in case of comments, I let you know. Okay, we are now
Yes.
in streaming on both the Creativity website, the YouTube channel, and the Facebook page of Creativity.
Oh,
Okay.
fantastic.
Let's go, and if in case I can even translate a little bit if you are going deep in detail, okay?
Yes, sure. Okay, so I'm sharing my screen. Do you see it?
Yes, we see your screen.
Yeah, great. So let's start our talk about intellectual property. What do we say? What do we think about when we say about intellectual property? What we mean under that? We mean creations of mind, because people create a lot of things, and something are material, some immaterial, and some combined material and immaterial stuff. But in all of those stuff, you have something that your mind created, and that is intellectual property. It unites such things as copyright, trademarks, patents, industrial designs, geographical indications, trade secret. We'll stop more on copyright, and I will just show you some examples of that. And if we are talking about trademarks, those are particular things that you want to those are marks that you want to show that this goods or services come from you. Like when we have Lego, you buy the Lego stuff, and you know that this comes particularly from this manufacturer, and no one else can do that. Patents, they rely more on inventions. If you invented something and you want to protect that, you can patent it. But in this case, you have to tell how you do that. And if you don't want to tell everyone how to do that, to show the process, to disclose it, you choose the other way, or to protect your invention, and that would go more to trade secret or some other things. Industrial designs, they are about putting together in some inventive stuff, some creative stuff, and some useful stuff. Like you've created an industrial design of a car. You created a car that has some particular features and appearance. Or it also can refer to some fashion stuff. Geographical indications are a very known thing, since if you have something, some wine or some product coming from that area, that name is protected, like champagne. And I've already said that trade secret, it protects something that you've created, and you don't want anyone to know how you make it. You want everyone to see just the result. So let's go. Let's move
question,
to copyright.
Just for first question, is we are used to say design and made in Italy in our country, and there's a sort of brand. Is it protected or not? I mean, just a question that is the first question that arrived.
What protected brand?
I say that we normally use in design in Italy. We are normally used to use the expression made in Italy, designed in Italy. Can we use for Italy in this case?
No, it's
that arrived on our channel.
Made in Italy, it's different, because here you refer to all the state. It's more shows where it was made, but the geographical indications, they are telling, they are connected with some very specific things that are on that region. For example, there's such thing as terroir, where you have a special ground, special natural condition. And for example, this kind of grapes, it grows only here, and it has only particular taste here, and you can produce this kind of wine only here. That is. Or you have some traditions of producing some sort of a product only on this territory. This is like what it means.
Thank you so much. Thank you so much. Please go ahead with your presentation. Thank you.
So what's most common and what we use very often deal with is copyright. Copyright protects the author, and it means that authors of a particular creation, they have some rights, and due to copyright, nobody else can copy their work or use it without permission of the author. Copyright relates so-called literary and artistic works, but this scope of works, it covers a lot of them, and some countries, they don't take only literary and artistic works. They add dramatic works, different domains. And these creations, they cover books, novels, poems, cartoons, songs, advertisement, photos, everything that could be created and gain protection. The list isn't exhaustive, and a lot of creative products are protected by copyright. So why copyright? It, as I've already mentioned, it protects the author from somebody copying or using their work. Let's see this example. For example, I've made a flower. I've made a drawing of a flower, and somebody copied that flower, but added some color. So it's sort of a derivative work of that. But I didn't give permission to do this. This would be an infringement. But if I've drawn a flower and I gave permission to do this, under certain circumstances, that won't be an infringement, and that would be okay. Another example, if I draw a flower and then somebody else draw a flower, also in black and white, but it's completely different flower, it's not an infringement. It doesn't copy my work. So this is the basic example.
How similar it must be to be risky, let me say?
Oh, you have to look at that at every particular case, because sometimes it's obviously visible, and sometimes you have to involve experts to say whether it's similar or not. It doesn't have any particular criteria that this is similar and this is not. For example, here you see these are these are different drawings of the same flower, but they are. It's not a photocopy. These were my drawings, yeah, but it copied a lot. You see?
Yeah, that's sure.
Yes. Yeah, and in case you want to claim your rights and to say, hey, somebody infringed my creation, and you go to the court, in the court you will have to present some examples of your work, and the court will probably involve experts, and they will say whether it was copied or not. So it's in every particular case.
Okay. You know, we are very sensitive in design because it's basically impossible in design not to copy or not to be inspired or not to be close to other ideas, because everything was invented. I mean, I don't think so. However, we normally say that it's complicated to go. The wheel was invented 3,000 years ago. So is it copyrighted or not? I mean, this is for us is a very delicate matter, because with the risk of being, I would say, of being close to the infringement is always a risk.
The copyright has the expiry term, because it doesn't last forever, first of all. Mostly their creation is protected 50 years after author's death, during the life of the author, and 50 years after author's death. But in different countries, different term may apply. For example, 70 years or 100 years. So it doesn't last forever. But for quite a long time.
Okay.
And in talking about the similarity, it also applies to different works, because one type of works you can have sort of a test how similar it is, and in other cases you have to look at the particular case. So let's move closer to the rights of the author. What kind of rights that the author has to his work? There are two main types of rights. There are economic rights and moral rights. So economic rights, they refer to the thing that you can gain profit from your creation. This means that if somebody reproduces, broadcasts, records, translates your creation, or use it in any way that you obviously allow, you can have money for that, typically royalties. You can have the payment one time, or you can have it for for each use of your creation. And economic rights, you can transfer them. They are transferable, and you can sell them or license them. I will talk a bit later. And there are moral rights. Moral rights are always with author, and they cannot be transferred. They can be only waived, like author waives his moral rights. And what what they actually mean? They mean that author can say that it's he who or she who created this work. It's the right to claim to mention the name of the author while using the work. And the other main right is to object to applying the changes that could affect the reputation of the author due to these changes. For example, somebody bought your work, your artwork, and wants to paint it red. And you, as the author, you say, for example, any sculpture. You've made a sculpture, and it has your idea of being of blue color, but the owner who bought this, he decided to paint it red. And you, as the author, you can object to this. This is your moral right that any changes could be applied to your work. So this is shortly about the rights of the author. And let's talk more about the economic rights.
Just because, just before going ahead, we are receiving some questions. One says that Fabio is writing and says if it's allowed to create something with the same concept, but with a complete different design. I mean, this concept the same, but the design looks different.
This is also the question that should be reviewed in particular case, how it looks. But going ahead, I will be discussing that later. This is the concept, the idea. The ideas, concepts, they are not protected. If you want to create something, like you want to paint a bouquet of flowers or sunflowers particularly, and you do that, and no one else is forbidden to draw sunflowers, but they have to do that in their way. So the idea itself is not protected. You can realize your idea differently, just not to copy somebody else's work. That's what it means. Yeah, did I answer? Max?
I have another question.
Hey?
It's about the YouTube platform that is full of video, and it's Elena says that it's different to understand the manipulation. The question: if I'm a musician and I want who wants to share a song using someone else someone else video footage, just with an artistic purpose, without selling anything, would be possible?
If you are just showing somebody's video, actually, it's by default, using somebody's artwork is forbidden. But there is a concept of fair use. You can use without permission, but by identifying the author. In cases you do a citation. For example, you are talking about this work and you want to illustrate your talk. You want to show that this is the artwork I'm talking, and this is how it looks like. This is an example of fair use. The other example, you use it in use, and also you talk about that, or you use it for educational purposes. Also, this has to be a fair use where you don't gain any revenues for that, but you are using that for education. In case you are applying somebody's video to your video and on YouTube, actually it may be considered as an infringement because even if you don't gain any revenues, you you are using you don't use it in this scope of fair use. It's just a suggestion because I don't see the particular case. But if your type of use doesn't doesn't meet the criterion of fair use, that would may be considered as an infringement. So it's better to ask the author first whether do you mind if I use it and put it in my YouTube video. Also, the YouTube has with the protection system where author can object and to put your video down. Yeah, did I answer?
Thank you so much, and please go ahead with your presentation. As soon as we have a question, I will give you the. I will publish here the paper.
So let's talk more about economic rights that I said they are transferable, and which are rights that give you the possibility to gain revenues from your artworks or your any works. There are such concepts as ownership, that you as an author, you own all the economic rights to your work. And due to this, you can transfer them. Transfer means that you completely assign your rights and you give them to someone else. And in this case, you have to be very careful. You have to remember that you are given all your rights and you won't be able to gain revenues from your work anymore. And very often this applies also to such called work for hire. If you are hired by someone to create the creation, then in some countries, due to legislation rules, and in some countries due to the contract, you are assigning all your rights to the work that was made for hire. Or also a commissioned work, when you want an employee, but you you entered into a contract that requires you to transfer all the rights to the work made under that contract for some fees, you obviously transfer. And in this case, you have to remember that the work is not yours anymore. Also, while signing such contracts, you have to remember this and be careful, because sometimes you may not want to transfer all your rights. And in this case, you also can negotiate. It's only when you are doing a commission work or you're not an employee, you can negotiate whether you want to transfer all the rights or some or give the license. The license is a more flexible thing, and it allows someone else to use your work, your licensee, and the rights themselves, they remain in you. You remain the owner of the artwork, and you continuously license it and get revenues. What's important about the license? You have to know what you are licensing. You're particularly saying that this artwork or this design, then how the licensee can use it. The work can be used only in the way it's written in the license. If your licensee uses it the different way, then it's considered as an infringement. The period. Also, their license defines the period during which the work can be used. And the territory, you can choose the territory. It could be worldwide, it could be just Italy, it could be Italy France and USA, you can choose this. Also, the license can be exclusive or non-exclusive. Exclusive, this means that only this particular licensee can use it, and no one else. And non-exclusive means that there could be different licenses on the same territory during the same period. And the same thing applies to you. When you are receiving the license, that is the rules that apply to you. Any questions?
Yeah, another one is Gaia Vergari. Gaia is asking, she is saying that if I translate a document from, for example, from English to Italian, I'm allowed to do it without citation, or is still necessary? I mean, if I'm using someone else's text and I translate it in my language, it's still covered by copyright. I hope that is the question that Gaia was asking for.
If the translated text is protected by copyright, yeah?
Okay.
Look, I will answer it the both ways, because if you take somebody's text and you translate it, you use it. And in this case, you even create a derivative work, because you're creating another text, you put your work in it, but still, to make a translation, you need to have a right to make this translation. This is the first point.
So
yes, the text is copyrighted
before.
And making a translation needs a permission. And second, if you made a translation, you gained the permission. Yes, it's okay to translate the text. You have a license and you've made this translation. This translation is also protected as a separate work.
So, okay, what is important, and if I understood well, is that you have to protect it, to ask before translating. The problem is not translation itself, but the fact that you have to be aware that before translating, you are risking.
Yes.
Because,
yes, it also depends how you are going to use it. Because if, for example, you are translating a citation from the text just to illustrate something, you are telling about this text, about this author, that falls into the scope of fair use. You're using such just a small text to tell your opinion of the author, and to show what that author was saying. It may, and you are not using it for commercial purposes. You're using it, for example, for teaching, and it applies particularly to the point of view of this author that you want to show. So it will be considered as fair use. But if you want to use that citation in your work that you will sell later, and you are using it in some video that you are going to use not for teaching or and not for and you're not using it there as a citation, but as the part of it, then you need to ask for permission, for license.
Oh, okay.
Okay.
Yes, I have another question. Is what exactly fair means? I mean, because probably fair is a little bit. I mean, has a big. It's quite broad in terms of.
Yes, and often authors. There are authors who want to cheat and to say it very often applies to some short parts. Oh, I'm using just 3 seconds of that video in my video, so probably it doesn't fall into licensing, and it's a fair use. No, the fair use is clear, because you are using it for citation. For example, you say that Max Pinucci in his work said this, this, and this, and you are using to illustrate your thought about that work, about Max Pinucci, or about some matter you are talking about. This would be fair use. And you are saying that this was said by this person, and you indicate that this is the work of that person. And in this case, it's a citation. Then, when it relates to this person in this case, and if you are taking just a part of the text and you put it in your text, doesn't matter how long or how small it is, you are using it, and you should ask for a license. So this is, or you are using it for teaching. In the, for example, you are having a lecture about famous artists, and you can show some artworks of this artist in order to illustrate your teaching materials, and to show what relates to this artist. Also, it has to be considered as fair use, because it's protected in this way.
Okay, it's interesting. It's very, for us, it's very complicated because
because a fair use. Yeah.
No, because I mean, as I told you, everything we do is inspired by other things. I mean, sometimes you can make a coffee machine that's inspired by an architecture. It happens. I remember especially a very famous Italian designer, Aldo Rossi, was using the same shapes and the same inspirations for both objects and architectures. So if tomorrow I do something inspired by another architecture that's not my architecture, let me say I design a beautiful coffee machine inspired by the cupola of the Duomo di Firenze. No, this is not because it's too old, probably, but it's inspired to an existing and actual architecture. The Canary Wharf in London. They make a nice coffee machine inspired by the Canary Wharf. Is it allowed or not?
First, you have to look at how similar is, how the inspiration comes to you. Because if you make a complete copy of somebody's artwork, that that is forbidden, that is protected. But if you are kind of using some sort of shape, or but not the exact shape, but you sort of do it in the way that it won't be considered as copied. Here we again come to the criteria. Then you have to look how similar is that, and how the inspiration goes, because very often people get inspired by something, and they really do the works that do not resemble the original the work that they were inspired from at all. This is the good example of inspiration, when it just uses some spirit or whatever that. But if you copy their exact artwork, if you copy some protected colors, and you make it the way it is visible that you made it by using that artwork, that protected artwork, it's not a good practice. It may be considered as an infringement. But yeah, as I say, it's a very sensitive thing, because it really should be reviewed in each particular case.
Thank you. It's always a problem in our domain. Let's think. You mentioned colors. I mean, if I use the Verde Veronese, the painter of the Renaissance, I mean, I can use it, I'm sure, but I'm not sure if I can use the Rosso Ferrari, the red of Ferrari.
Yes. Yeah, that
For us,
is.
but at the same time, Rosso Ferrari is a Pantone, but at the same time, Pantone is copyrighted.
Yeah.
So
Yeah, at the same time is protected, and you cannot use it in your work, and especially if you are doing a car.
sure. So, but it's
Yeah.
I think that this it's thank you so much because it's you are opening the Pandora vase. You know, you're
Yeah.
opening a really big and messy
Very
messy.
messy, and that could be that should be reviewed in each particular case, as I said. And I've met sort of frequently asked questions section, because there are questions that I was facing authors were asking, and very often, because there is among very young authors, there's a common conception: oh, it's on the internet, and can I use it in my work? And I often answer that no, if it's not, if it's just on internet, you find it through, for example, Google Pictures. You cannot take that picture because you just can copy it. Every object has the author, and in order to use it, you have to find out who's the author and what are the terms of using this object. Because not very, but often there are works and there are websites that allow to use the works that are on them. There are different types of Creative Commons licenses which just make your work free and everyone can use it, but you have to read the terms carefully, because sometimes such free licenses, they allow using it in any way, but you just have to mention the author everywhere, or you have to allow your work to be used by others in the same way. And this is a tricky thing, and especially, for example, in software. If you are creating some software or some graphic interface, and you put at least, for example, their piece of code that is under the scope of GNU license, that is sticky. It requires that if you use their part of code, in your code you have to make your creation, your program, or in our case, for example, a graphic interface, also the code of it, they're also publicly useful, that you don't have to put restrictions in use of that for that to be used in the future. And there are different
sort of an exchange. I can use your parts of programming or your parts of code, and I have to give my code to you.
Yeah, not you, but to others. That's the matter of sharing with everyone. It's like I give my code or I give my artwork to everyone, and if you are using this artwork in your or this code in yours, you have to give yours creation to everyone.
Okay. We are having another question. Is Rona is asking if you can if there is a way to deposit a creation. I mean, she's asking if you recommend to deposit the creation or is already protected by the laws of the country.
You mean if you have to register your copyright?
Exactly. I mean, the question is, it's better. I hope that Rona is asking if it's better first to deposit the creation, or you think, or you can be sure that your creation is already protected by the law.
In most countries, your creation is already protected by law. But in some cases, you may need this deposit, this registration, and you have to decide. You just have to think whether you need this for additional protection or no. For example, it happens with digital works. When it's hard to say that it looked like that I've made it and I've used it and it always been like that. In this case, you just register it, and if you want to use it further, or you want to license it, this registration adds additional protection and shows that your work existed at that time, and you are the author. Also, in digital works now, WIPO, the World Intellectual Property Organization, they are introducing their new system where you can make a digital fingerprint of your digital work, and receive a token that would certify that at this particular time you were the author, or this creation existed and you were the author. But you have to pay for that, obviously. But you have to decide whether it's economically whether you have an economical business need for that. As in most countries, you don't need your work to be registered or somehow formally approved that in order to have the protection. Your work is protected by copyright, by law.
Okay. So thanks. I think we need. I mean, there is another question. Is about the where we can find other informations.
Oh, other informations. I would recommend WIPO website. It's World Intellectual Property Organization, where they have all the legislative texts, where they have materials, and also they have courses on intellectual property. Some of them are free, and it's a good source of further information.
Okay, I think we saved half an hour. Now we have 45 minutes. I think is great. I mean, we enjoyed. I really hope that we can stay in touch. We will be published on the creativity page your contacts in case, and if you want, obviously, and if you have some sources, some informations, some websites, then we can publish in order to let students to read them and to check them before asking and before doing these things. I really think it should be good for us to have some.
Yes, and it's always a good advice. If you have any questions, you should ask a professional, particular lawyer, because it's better to ask first and than to have problems later.
Yeah, we had a problem. I remember that you mentioned the fact that if you are working in a studio or in a company, it's another complicated thing, because it happened to me, to a student. He published a photo on his portfolio of an object that he designed for the company he was previously working with, and they got very, very angry. because of this, because the product was the company, but he was a designer. So it's again something very, and he wasn't doing anything else than showing his work in his previous company. So it wasn't just like to sell it or to resell the same work to another possible customer.
Yeah, in this case, it's, as I say, it should be reviewed this particular case, because, for example, in the USA, if you are creating, for example, a movie, a company, the producer, that can take all the moral rights, and the company becomes the owner of all the rights. Here, in this case, it works like that, and you cannot say, Tarza, that I was an author. In in other countries, because we have to look at in which country it happens and under which legislation was the contract concluded. For that, yeah, there are different factors for which every particular case should be reviewed.
Okay, it's complicated. So I have another comment. I know it's just Guy that is saying thank you very much, Olga. And so we are very happy to open this. I told you this huge domain in creativity, because creativity talks about creativity. Creativity means copyright for sure. So thank you so much. I think that it would be great in the next edition to probably have you as a guest because I think that even a workshop would be interesting in these things.
Yeah.
Okay. Thank you again. Greetings from Italy, and see you.
Yeah. See you. Bye.
Grazie a tutti e buona giornata da Creativity. A presto.